All right, it's 9:13 right now, and we're back with breaking news. A big decision that much of the country has been on pins and needles about, really, for the last several weeks. Dobbs versus Jackson Women's Health has come down there in D.C. Justices have effectively overturned the landmark Roe versus Wade decision that granted federal abortion rights. And this is a live look at the Supreme Court building as the decision just came down. We're going to be giving you new information as we get that information in, but we also want to have a broader discussion about what just took place.
So let's bring in political science professor Stephen Caliendo from North Central College with us.
Good morning to you. So the court just decided to overturn Roe v. Wade. What does this mean?
Well, it means that that there's no longer constitutional protection for women to terminate a pregnancy in the first 2 trimesters of pregnancy. And it means that states who wish to outlaw that procedure, to make it illegal or even criminal, are able to do that, and certainly will do that. We know that a number of states had so-called trigger laws in effect, waiting for this decision to happen, and those will go into effect immediately.
So Illinois is one of those states where it is not going to be an issue. Explain that, and let's talk about the difference between Illinois and the other states and what this might mean for abortion in the future.
That's correct. So the Supreme Court did not say that abortion is illegal. It said that women do not have a constitutional right to the procedure under the terms that were discussed or that were outlined in 1973 in Roe versus Wade. What it means is that it's no longer impermissible for states to outlaw the procedure as it has been since 1973. States like Illinois, who will protect the procedure, will continue to do so. I think the real question then is what happens if Congress changes next year to a Republican-controlled Congress. If there's a federal law that outlaws the abortion procedure, then we're in a different situation because states cannot have laws that violate federal law. And so down the road, not too far, we may be having a different conversation about this. But immediately, Illinois women who live in Illinois will be protected. I also think we might be seeing some influx into Illinois for women who live in states where the procedure will be outlawed. Certainly there'll be some organization from not-for-profit groups around that as well.
Yeah, there's certainly been several lawmakers who immediately after the leak even said Illinois is open. So you could certainly say that more people would be coming this way. But what could the president do about a decision like this? We heard him earlier in the week when the gun law for New York was, that decision came down. He immediately came out and said he was disappointed with the court. What do you think he could do about this?
I certainly expect that we'll hear something from the president today. I'm certain that there's been a speech drafted for some time, probably at least since the leak came out a couple of months ago, or last month rather. But I think in terms of an executive order or any kind of formal legal procedure, I know that the White House had been exploring that. I don't know if we have much information on what's available. Certainly, it's not permissible for the president to simply say that women in the United States have a right to their own reproductive health, in contrast to state laws and in contrast to now what the U.S. Supreme Court has said. So it would have to be something procedural or something a lot more nuanced than what we had even in Roe versus Wade.
Does a decision like this foreshadow any other decisions that could come from the court a little bit later on, considering the makeup of the justices as well?
Absolutely, no question about that. I'll be interested to read the decision. As you said, it just came a few moments ago and I've been with you. But you know, the draft that we saw really hinted at the fact that the underlying legal reasoning that Roe was centered on was faulty. If that's the case, then other legal reasoning that relied on Roe could also be considered to be faulty. And so now we're thinking about things like gay marriage and even contraceptive health, right? The right to contraception. The Griswold decision, for instance, relied on this notion that there's a fundamental right to privacy around reproductive freedom, particularly in the Griswold case, in the sense of a married couple. But that's been expanded, of course, in various ways, including the right to gay marriage. And so, if that legal doctrine is eroded, we certainly can see other challenges to rights that have been extended by the court in the last 30 or 40 years.
Okay, Stephen Caliendo with North Central College on the fact that the Supreme Court has overturned Roe v. Wade. We're going to have more discussion on this, but we do appreciate you joining us this morning.
Thanks. Good to see you.
Take care. Yeah.